Shout out to Philadelphia, Pennsylvania. That's the MARC train, or yeah, I think they call it the MARC train, going across the bridge there into South Jersey. I've actually watched across that bridge, one of the scariest times of my life. Anyway, welcome back to America's Voice Live, folks. The U.S. Supreme Court is expected to hand down a ruling on affirmative action in the next month or so. The group Students for Fair Admissions is suing Harvard University and the University of North Carolina for using race as a factor in admissions. The Supreme Court ruled in 2003 in Grutter versus Bollinger that University of Michigan's law school could use race as a factor in admissions in order to produce racial diversity in the student body. But many argue that this practice is just reverse discrimination. Joining us live now to discuss this highly controversial and emotional issue is campus reform fellow and attorney Ken Tashjy. Ken, good morning.
Talk to you. Thank you very much for having me.
Glad to have you. Welcome. So the current justices on the high court have already shown a willingness, if you will, to strike down landmark cases, specifically Roe v. Wade. So with that said, how much do you expect the justices to consider that Grutter versus Bollinger ruling in reaching a decision on the Students for Fair Admissions case?
Well, I think they're going to give it a lot of weight. I think when the court originally ruled that race could be used as a factor in admissions to create diversity in higher ed, they were very clear that that factor race should only be considered as one factor among many factors when making that decision. Unfortunately, over the years, that's morphed into a process where race is considered not just a factor these days, but in many cases, it's considered the factor for admission purposes, and it's become predominant or determining in admission decisions. And I think the court's going to recognize that has strayed very far from the original intent of the use of race. And as a result of it, they're seeking to create racially proportionate admissions through the use of race, which really is nothing more than racial balancing or the use of racial quotas, which are illegal. And I think that's the direction the court will go.
Ken, how are you able to quantify just how much some of the universities are using race as part of their admission standard? Like, is there a rubric? How can you quantify how much race is being used?
Well, I mean, that's a challenge. The court always said it was supposed to be just a factor among many factors to determine the student's contribution to the education environment. But what we've seen and heard over time is that it's taken on a much a stronger consideration than that. You only need to look as far as the counsel for Harvard during oral arguments before the court, who admitted that race is a determining factor in admissions at Harvard in some cases. So it clearly is evident that it's giving much more weight than just one of many factors, which was the original intent of the court.
So I'm curious, if the court does decide that race cannot be used at all as a factor in admissions, what do you see as some of the broader implications of that sort of ruling?
Well, the impact is going to be not just for Harvard or the University of North Carolina, but this will be nationwide. It'll impact higher educational institutions across the country, both publics and privates. They'll no longer be able to use race as a factor in admission consideration to create diversity. And we've got 9 states currently that have outlawed the use of race in admission. And those institutions still boast very broad diversity rates, still maintain their academic competitiveness through a series of race-neutral factors for consideration. And I think, institutions are going to have to start looking long and hard at their current procedures and start evaluating and implementing alternative race-neutral programs and considerations moving forward.
So, Ken, let's kind of take a step back, because I believe, based on my own research, that we're kind of at this point because there has been somewhat of a history in this country of denying minorities access to education. In some cases, integration of certain universities actually didn't even happen until the late 1960s. So how can we actually reform the system to ensure that everyone has the same chance at admission?
Well, I think part of what we're going to analyze now are these race-neutral options. And when you talk about race-neutral options, you talk about shifting your focus from solely and exclusively considering race and starting to look to achieve diversity on campuses through other means, like focusing on socioeconomic class or geography diversity or ideological diversity or experiential diversity, which can create a much broader base of diversity than just simply focusing on race. Where really the only evidence you have in an application of how that will impact the student's admission is simply by checking a box. And we need to really get away from that mechanical process and do a much better job at evaluating all aspects of the way a student can contribute to a diverse educational environment.
Ken, I hear you on its face. It sounds like it makes a lot of sense. But if you really look beyond what you're saying, it's still discrimination. If you're choosing someone, or if you're using a factor like socioeconomics, that's discrimination for someone who may not have a certain or be of a certain socioeconomic standard. If you're using geography, that's also discriminatory, or it could be argued that it's discriminatory for someone else.
Well, the reality, though, under both state and federal law is race used in that context is illegal. Racial discrimination and the use of race to classify and separate individuals is illegal. It's never benign. It always has negative consequences. But you still can consider other non-racial factors like geography, like socioeconomic status, even though those may impact more predominantly one underrepresented class or another. It still is a permissible area for evaluation, and that's the direction I believe the court is going to shift higher education's admissions focus.
It sounds like someone's always going to be left out. Do you see this actually being a situation that can be fixed, that will satisfy everyone, or is there always going to be someone who's going to be willing to sue because they may be left out of an admission?
I think, unfortunately, there's always going to be individuals that are going to believe that an admission decision wasn't predicated on their academic record or their activities or things like that. They're going to boil it down to claim that it was somehow their race, either it worked for them or against them. I'm going to suggest that the further we get away from the racial consideration, the less those challenges are and will be viable, because, again, we'll be focusing on other criteria. But I should add, though, that if that other criteria is nothing more than an effort to discriminate and it's masqueraded as something else, then there's still going to be a great deal of vulnerability for institutions. So they have to really work hard at removing race from consideration and looking at these other factors.
Before I let you go, I'm just going to ask you a theoretical question, because all of this is predicated on the idea that these universities want to have a more diverse student body. How important is it, in your estimation, to have a diverse student body? Does that really ultimately benefit the students?
Well, look, their position is diversity is a critically important factor for the educational environment. And while they say that, unfortunately, they've also supported, as of late, an extensive amount of racial segregatory practices on their campuses. We've seen an exponential increase in minority-only graduation programs, minority-only housing opportunities, minority-only student orientation programs, all of which, frankly, is antithetical to the claim that diversity is a paramount interest in higher education. It's unfortunate, too, because it's really overshadowed what should be the commonality of shared experience between students, and replaced it with this sort of grievance mentality and a view that there are irreconcilable differences that we just can't reconcile. And that's unfortunate for a society and culture that's supposed to be working towards colorblindness.
Ken Tashjy, will have to leave the conversation there. The J is silent, by the way. Good to see you, my friend. Thanks so much.
Sir, thank you very much for your time. I appreciate it.
All right, we'll talk soon. Coming up after the break, there will be a new chairman of the Joint Chiefs of Staff. We'll tell you who it is next.